Did you know your home could be seized over council tax without a real court judgment? Councils are pulling a legal stunt. They slap a charge on your property using nothing but a liability order, rush through court in bulk with zero real evidence and no proper hearing. Then they send you court-headed papers from something called the County Court Business Centre. But it's not a court at all. It's a paperwork factory. No judge, no justice, no legal authority. Here's the kicker. Under UK law, a liability order isn't a court judgment, and without a judgment they have no power to touch your home. This entire process is a legal illusion, unlawful, ultra vires and dead wrong. If you've had a charging order slapped on your home, don't panic, but don't stay silent either, because what they're doing has no legal ground, and it's time the truth came out. Today we are exposing a serious flaw in how councils enforce a liability order obtained under the Council Tax Administration and Enforcement Regulations 1992, by then placing a charge against someone's home using a process that, in law, is unlawful, ultra vires and without lawful jurisdiction. Councils start by filing a complaint to apply for a liability order in the Magistrates' Court. Regulation 34 of those regulations requires the court to issue a summons for the person to appear and explain why they have not paid, and then for the court to be satisfied through evidence that the debt is properly due. That is a judicial act, demanding a fair opportunity to be heard and a genuine finding of fact. In practice, however, these hearings are processed in bulk with dozens of cases listed at the same time in a single courtroom. Public listings like this show 15, 20 or more liability order applications crammed into the same time slot. There is no realistic opportunity for a genuine hearing or for evidence to be properly tested. It is in truth a rubber stamp procedure, and that conflicts directly with the safeguards Regulation 34 was meant to protect. And yet, even if Regulation 34 requires a judicial act, Regulation 35 Section 3 then confirms there is no sum adjudged to be paid by order of the court. It expressly removes any judicial quality from the liability order. That means the Magistrates' Court cannot actually exercise the proper jurisdiction of a court in granting a liability order, because there is no judicial finding of a debt in the true sense. Nothing is adjudged, no contested evidence is determined, and no true judgment is issued in the way due process requires. What the Magistrates' Court is doing is a legal nothingness. It is an illusion of judicial authority, dressed up in court paperwork, but without lawful substance. After the liability order is granted, without meaningful judicial oversight, the council then applies for an interim charging order to secure the alleged debt against the person's home. They do this by relying on Regulation 50 of the same 1992 regulations, which permits a council to apply for a legal charge on land after a liability order has been obtained. Regulation 50 Section 1 says, the council may apply to the county court if at least £1,000 is still outstanding. Regulation 50 Section 2 then says the court may make such an order on such application. However, Regulation 50 only permits the council to apply. It does not force the court to grant a charging order if the legal conditions are not satisfied. Section 1. Subsection 1 of the Charging Orders, Act 1979, is clear. A charging order may only be granted where there is a judgment or order of the High Court, Family Court or County Court requiring payment. That means there must be a qualifying judgment, not merely an administrative order. Regulation 35 Section 3 confirms that a liability order is not to be treated as a sum adjudged to be paid by order of the court. Therefore, the county court, even if faced with a Regulation 50 application, cannot lawfully grant a charging order because the necessary judicial foundation is missing. That application is then sent to the County Court Business Centre. The clue is in the name Business Centre, not a courtroom. This is an administrative, computer-driven, paperless mass clearinghouse where no judge examines live evidence, no proper hearing is held, and no judicial reasons are ever published. It is an entirely administrative process, dressed up in court-headed paperwork, but with no genuine judicial scrutiny. The interim charging order is then posted to the person, warning them their home is at risk and stating they have a right to object, but it does not explain how to object or what precise legal grounds to use. For most people struggling to keep a roof over their heads, living month to month, finding the time, money, or knowledge to mount a complex legal objection is near impossible. Most will do nothing because they cannot afford a solicitor or do not know how to defend themselves. The interim charging order is then posted to the person, warning them their home is at risk and stating they have a right to object, but it does not explain how to object or what precise legal grounds to use. For most people struggling to keep a roof over their heads, living month to month, finding the time, money, or knowledge to mount a complex legal objection is near impossible. Most will do nothing because they cannot afford a solicitor or do not know how to defend themselves. If they do not object correctly, the council then proceeds to apply for a final charging order, which, by the way, happens by default if no objection is raised within 28 days. Once again processed through the CCBC with no proper judicial hearing. As a result, a full legal charge is registered on your land title without any judicial decision ever taking place at any stage. That is unlawful, ultra vires, and without lawful jurisdiction. If someone does manage to object, they are then listed before a judge, but unless they can present the precise legal argument, namely that a liability order is not a qualifying court judgment, they are very likely to lose. Although councils rely on Regulation 50 to justify placing a legal charge, Regulation 50 cannot override Section 1, subsection 1 of the Charging Orders Act 1979, nor can it expand the Local Government Finance Act beyond what Parliament actually intended. It is subordinate legislation and cannot transform a liability order into a valid judgment of the court. If Regulation 50 is interpreted to permit a land charge based purely on a liability order, then it goes beyond the powers Parliament granted and is ultra vires, legally void. This entire process creates the illusion of lawful enforcement, an interim order, a supposed right to object, a final order, all written on formal court letterheads, but in truth handled by a paperwork-driven business centre with no genuine judicial scrutiny. People who cannot get legal advice or do not know the correct arguments are effectively trapped. Their homes are placed at risk on the back of a liability order that is not, in law, a qualifying judgment. Regulation 35 Section 3 exposes that contradiction and reveals the truth. No charging order can lawfully be made on a liability order alone, and we have not even begun to address the constitutional statutes of this realm, which confirm that such enforcement is void in law and holden for error. If a council ever tries to place a charging order on your home for unpaid council tax, demand to see the proper court judgment under Section 1, subsection 1 of the Charging Orders Act 1979, because a liability order is not enough. If you found this video helpful, please be sure to click the like button and make sure you are subscribed so you don't miss any new content. Also, help us spread the knowledge by sharing this with others. It just might save someone facing a council tax charge on their home. Remember, no court judgment means no lawful charging order. Full stop. Don't be fooled by official-looking paperwork. You have a right to due process in law. Demand due process. Demand lawful authority. Refuse intimidation. Stand firm in your constitutional protections. Knowledge is power. Use it. Defend your rights. This video is for educational purposes only. It is not legal advice. You should seek professional legal counsel before acting on any information presented herein.